Yeah, well, what do you think about that though? What do you think about the this idea that I mean, clearly the style of Democrat that Hillary Clinton is entirely and wholly different than with some similarities than Bernie Sanders and the this leadership council style Democrat that is really run the party. Are you would you say to someone who's walking away and saying I'm going to vote green, for instance, would you say that the risk what do you say about the risk of a Donald Trump versus the Hillary Clinton when a lot of people feel that Hillary Clinton, her policies are just as repugnant as a Donald Trump would be, save the Supreme Court decisions and choices?
Well, I think you could probably come up with 20 or 30 areas where there are profound differences between Hillary Clinton and Donald Trump. I mean, that argument doesn't hunt. You know but
But
you know
the sentiment is out there, though.
no, I understand, and the reason why I keep going back to the Supreme Court is that when this country was put together, I mean, there were a lot of things that the founders got wrong, and one of them that, frankly, I think that they got right and then got made wrong was having three branches of government that can provide some sort of balance to each other, rather than any one of those three branches of government being the one that basically takes over and runs everything. And the Supreme Court, and you can read this in the Federalist Papers, Federalist 77, 78, 79, as I recall, Hamilton writing about this stuff when they were selling the Constitution, and they were talking about the role of the Supreme Court. Or simply read Article 3, Section 2 of the U.S. Constitution. The Supreme Court, in Article 3, Section 2, it says that the Supreme Court shall operate under regulations established by Congress. And that, you know, it's the court of final appeal, but under regulations established by Congress. And Congress has not regulated the Supreme Court in any consequential way. And in 1803, in a case called Marbury versus Madison, for the very first time in the history of the United States, and we were a very young country at that time, it was during the Thomas Jefferson presidency, the court ruled that they could strike down a law that had been passed by Congress. Well, nowhere in the Constitution does it say that the court has that power. And Jefferson went nuts. And I've written about this in several of my books. He said, if this decision stands, then the Constitution has become a thing of wax in the hands of an unelected judiciary. And then he went on to another rant about how, you know, judicial tyranny, unaccountable to, you know, accountable to nobody. And, you know, and then he was asked by Spencer Rowan, Patrick Henry's father-in-law. He was the governor of Virginia at the time, or something. I forget his role, but anyhow, Spencer Rowan sent him his long letter saying, well, you know, if the Supreme Court can't decide what is and isn't constitutional, who can? And Jefferson replied saying, the people themselves, which is the title, by the way, of a book by the dean of the Stanford Law School about this very issue and about how the people themselves should be the final arbiters. And Jefferson said the way that the people would exercise that is, let's say Congress passes a law that's, in the opinion of the American people, stupidly unconstitutional. It's not the role of the Supreme Court to knock down that law. It's the role of the American people to throw out those legislators and replace them with people who will undo that law. Wow. And that's the process. But in that 1803 decision produced such a huge blowback from Jefferson and pretty much everybody else. The founders were all alive then, or most of them, that the court never again, until 1856, struck down a law passed by Congress. They became what was referred to in history books as the dogs and chickens court, because America was a very agricultural country, and a very large number of the cases that got to the court and went through our court systems were fights between farmers, and very often about this guy's dog ate this guy's chicken, you know, who's responsible to pay. And the second time the Supreme Court said, we're going to strike down a law, it was in 1856, and it was in a case called Dred Scott, and, you know, which led us right into the Civil War. So, you know, there was a clear consensus prior to the 1870s, the 1880s, that the Supreme Court should not be overturning laws passed by Congress, that the Supreme Court should simply be the final court of appeals. Since basically the 1920s, the slaughterhouse cases, I'm forgetting the name of the era, who the Supreme Court justice was at that time, when they knocked down the child welfare laws, they as unconstitutional, the child labor laws, and knocked down the minimum wage as unconstitutional, et cetera. And that happened, the Lochner Court, that happened from the 1920s up until roughly 1937. The court started this whole, we're in the Constitution business thing. And they haven't stopped. And nowadays, virtually every decision the court does is whether or not something's constitutional. This was never envisioned, or maybe envisioned by a few of the founders, but it's not, it's not what's in the Constitution. So what has happened is one branch of government has made themselves absolutely supreme over all the others. They can stop the president, they can stop Congress, they can literally invent laws. No law has ever been passed in the history of the Republic, or even proposed in any state legislature or in the federal legislature, that says that corporations should have the rights of human beings under the 14th Amendment, or that giving money to politicians is a First Amendment protected free speech right. And in fact, politicians and Congresses have written laws saying the exact opposite of both those things, thousands of times, both nationally and federally. So the Supreme Court has literally created these two laws, and we're going to have to amend the Constitution to get them out. It's mind-boggling, the power that the Supreme Court in the United States has taken. Supreme Courts in other countries, other developed countries, don't have this kind of power. In Germany, for example, there is a constitutional Supreme Court. It's separate from their main Supreme Court, and it very rarely decides on anything. And it has nothing close to the power of our Supreme Court. So it's like, this is a really big deal. The president nominates people for the Supreme Court. The Supreme Court can alter, and does, the history of America with these decisions based on the Constitution, even though, in my opinion, they don't have the legal authority to do it. My opinion doesn't count. They're doing it, and sometimes to the good, it seems. 1954 Brown v. Board, 1973 Roe v. Wade. Sometimes to the bad, Citizens United, McCutcheon, things like that. So we can't ignore the Supreme Court. And anybody who says, oh, well, it's just going to last for another 40 years, whoever gets put on the Supreme Court, it's not that big a deal. They don't understand the reality of what has happened, how America has been hijacked by 9 unelected people.
You've actually, I don't think I've ever heard that position from, I've heard that position from Mike Huckabee, right? I've never really heard that.
Oh, you'll hear it from Newt Gingrich.
Yeah. I never really hear it from progressive voices, and it's ironic. I think today is the 1-year anniversary of Obergefell versus Hodges, where we essentially made marriage equality nationwide. And so you're saying, even to the benefit or to the detriment of American society, you feel that Marbury versus Madison was just something that they gave themselves power that they should never have.
Yeah, Jefferson was right, and even in those cases, and this I've had Phyllis Schlafly on my program a number of times. She wrote a book about this called The Supremes, and by the way, a lot of progressives agree with my position. In fact, I think probably most progressives who are informed about the court. But her point was that in 1973, in the Roe v. Wade case, she was like, you can laugh all day long, Tom, thinking that this is the court doing your thing and helping your side out. And isn't that wonderful? But the reality is that because the court did that without the authorization of the people, because the people didn't do it, it built basically the anti-abortion movement. Had it been a state-by-state process that eventually led to a federal process where lawmakers who were elected by the people chose to legalize abortion nationwide, there would not have been that blowback from the anti-abortion forces, or they would have lost most of the moral authority to have that blowback. And by the way, that was coming, because in 1968 there was a I'm old enough to remember this. I was 17 years old in 1968. In 1968, there was a nationwide measles epidemic, and there was something like 30,000 deformed babies born that year as a result of that measles epidemic. They had not yet developed a vaccine for measles. And so measles exposed young women wanted to get abortions, and it was illegal in the United States. And it was a huge, I mean, this was all over the newspapers, this was being debated on television. People who weren't, who aren't as old as I am have no recollection of this. But the legalization of abortion was absolutely inevitable. Now, it might have taken an extra 10 years, and you can say, oh my God, in those 10 years, think of how many people, how many women would have died, or how, the terrible consequences, and that's true. But that said, it would have been a much, if it took 10 more years, but it was done legislatively, it would have put the issue to rest, basically. Wow. So, and for example, we're still seeing states fighting Brown v. Board.
Yeah.
I mean, look at what's happening all across the country. They're still literally fighting Brown v. Board, which is not to say that it shouldn't have happened. I was very pleased that it happened. But even when the court does things to help us, that's not the end of it, and people just, this goes back to my argument about, the great man theory of history and, getting the perfect politician and all that sort of thing. It's like, again, the perfect Supreme Court ruling, it's salvationistic thinking. We need to take control of our own destiny. We need to be participating in the political process, and that means inserting ourselves into the system.